All right, we can go off the record. So here's my question. Why the tears?
I'm signing my life away.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, that the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. If you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things.
Today we're in Judge Boyd's courtroom, and right away we're dealing with an entitled defendant who suddenly discovered his emotional range now that he's being caught. The waterworks are on full blast, like someone cranked open a busted sprinkler, but not a single tear comes with real accountability. And Judge Boyd? She's been on the bench far too long to confuse acting with remorse. This isn't her first trip to the sympathy circus. The defendant is trying to sell a tragic backstory, but the judge bought that storyline years ago and returned it for store credit. The tension is already thick because she's clearly not buying into this Oscar-worthy audition. So the real question is, are these tears going to soften the landing, or are they about to make the hammer come down even harder? Let's dive in.
And are you Joe Jimenez?
Yes,
Counsel, have you received all discovery? Did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jimenez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Yes. All right. And there's also an enhancement paragraph. Are you proceeding on the enhancement in each count?
So just regarding count one, regarding count two.
Okay, I understand. All right. All right, Mr. Jimenez, did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count one, you're charged with aggravated robbery. If the state is able to prove up the enhancement allegation, your range of punishment is anywhere from 15 years to 99 years or life, and a possible fine up to $10,000. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. All right, just one moment. You're charged with unlawfully carrying a weapon with a felony conviction as a third-degree felony. The range of punishment for that offense is anywhere from 2 to 10 years. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 15 years in count one, and in count two, they're not. That is, you're right. Okay. So according to the plea bargain agreement, you're to be sentenced to 15 years in count one. In count two, you're to be sentenced to 10 years. Counts one and counts two will run concurrently. Is there anything, because I'm trying to do it from memory at my first glance of the paperwork. All right, and there's a $2,000 fine. Did you understand that to be your plea? Defense is at the plea.
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest? To the enhancement under count one, how do you plead? True or not true?
True.
To count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
The offer states one attachment.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to a jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
This is where things get wild. This man is facing a possible life sentence for aggravated robbery, and somehow he thought it was a genius move to pick up a firearm afterward and stack even more charges on top. Like, was he expecting a loyalty discount for repeat recklessness? At this point, it's not that he didn't learn his lesson, it's that he never even paused long enough to consider one. When you're already staring down a charge that can bury you forever, the last thing you should be doing is handing the prosecution extra ammunition, literally and figuratively. Now he's sitting here crying, and it's hard to tell whether the emotion is genuine or just courtroom cosplay designed to rack up sympathy points. Then again, most people would start leaking tears the second they hear the words possible life sentence attached to their name. The only thing working in his favor is that his attorney somehow pulled off a miracle tier plea deal. 15 years on one count, 10 years on the second, running concurrently. Basically a buy one get one sentencing special. So now the ball is in Judge Boyd's court. Does she accept the deal, or does she decide that this man's decision-making was so catastrophically bad that even the plea agreement isn't enough? Should she stick with the 15, go higher, or shock everyone by going lower? Because let's be real, cutting a life sentence down to 15 years is a massive legal win. His attorney deserves a trophy for negotiating that. What makes this hearing hard to watch, though, is this man acting stunned by consequences he personally engineered. The only person responsible for this disaster is the one sitting in shackles, pretending this all just happened to him.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1 and counts 2. The court will find you guilty of counts 1 and counts 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you waiving PSI?
Yes, Your Honor.
All right. In count 1, the court will sentence you to 15 years in the prison, give you credit for any time served. The court will sentence you to 10 years in count 2, give you credit for any time served. In count 1, there's an affirmative finding of deadly weapon. Counts 1 and counts 2 will run concurrently. There's a $2,000 fine. Is there anything else with regards to sentencing?
Yes, Your Honor. He had a federal case that he got 17 months on. He entered custody on May 12th of 2022, which is 3 weeks after this case. And he's been in continuous custody since. I believe he was released from Karnes County, which is the federal penitentiary, where they're holding him actually on September 24th, 2024. But he has been in continuous custody since May 12th, 2022 to present.
Oh, he'll receive credit for that time.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So here's my question. Why the tears?
I'm citing my life already.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. So what I can tell you is, if you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things. Well, I mean, you had a chance to be in the free world, to be with your children and your wife, but you chose this. So this is where we are. If you would have gone to a jury trial and a jury would have found you guilty, let me just tell you, based on my experience, you know what a jury would have done? They would have looked at your tattoos. They would have known what those tattoos meant because they would have been told what those tattoos meant during punishment, and they would have gave you life, and they would have went on their way. They would have gave you life on that case. And for the gun case, they would have given you the maximum. So if you don't want to be standing before a judge crying about your wife and children, then stop doing this. All right. Good luck to you. Oh, thank you.
Thank you.
Oh, thank you. You have a good one.
And here's the part that really puts things into perspective. With how intense this hearing sounds, you'd think he robbed a bank or pulled off some massive heist. But no, it turns out he threatened someone's life over a beer. A beer. Let that sink in. Imagine risking a lifetime in prison because your impulse control flatlined and your common sense clocked out early. How bad does your judgment have to be to torch your entire future over something that wouldn't even cost $2 at a gas station? Judge Boyd was absolutely right to shut down the tears immediately. Nobody in that courtroom is buying emotional clearance sales today. You detonated your own life over a can of alcohol, and now you want mercy like this was some unavoidable tragedy. Honestly, he's incredibly lucky that the plea deal capped things at 15 years. If this had gone to trial, a jury would have handed him a full life sentence before lunch without a second thought. It really makes you wonder how many lives get permanently derailed every year because of one split-second, zero-thought decision. So what do you think? Does 15 years fit the crime here, or is it still too high or too low? Drop your thoughts in the comments. Thanks for watching, and don't forget to like and subscribe.